afternoon, everyone. We are going to begin the webinar now. So first of all, I want to thank each of you for joining the ADR Committee of the Bahamas Bar Association for this webinar on mediation as the next thing. My name is Theominique Nottage, and I am Vice Chair of the ADR Committee, and Mrs. Lashley is the Chair of the ADR Committee. And today I will be acting as your moderator for this webinar. So before we get started, I just wanted to provide a brief overview of the webinar and address some housekeeping matters. So firstly, this webinar will feature presentations by Judith Knieper, Legal Officer at UNCITRAL, and she will be presenting on the UNCITRAL Mediation Framework. And then we have Mrs. Kelphene Cunningham, a fellow of the Chartered Institute of Arbitrators, who will be discussing the draft International Mediation Bill. We have Mrs. Caryl Lashley, also fellow of the Chartered Institute of Arbitrators, who will be presenting on the Domestic Mediation Bill. And then myself, I will be presenting on the role of the government. Thereafter, we're going to have a question and answer session. Should you guys have any questions on anything that we've discussed this afternoon. Secondly, again, in relation to the questions, if you do have questions during the course of the webinar, please use either the chat function or the Q&A function, whichever is available to you. And time permitting, we will address these questions at the end of the webinar during the Q&A session. Thirdly, if you have access to video and microphone, please keep your microphones muted unless you are speaking. I'm getting a bit of feedback now from some of you, so I would ask if you could kindly mute your microphones just so that we hear each of the speakers very clearly. Finally, we confirm that there will be a recording of this webinar made available via the Bar Association's listserv, and we also will make available the materials for this webinar. So it's now my pleasure to introduce our speakers. First, we have Ms. Judith Knieper, who is the legal officer at the Secretariat of the United Nations Commission on International Trade Law in Vienna, Austria. Until her appointment to the Secretariat, she had been working in Southeast Europe from 1998 to 2013 for numerous.
Yeah. Huh?
For numerous donors organizations, for example, OSCE, COE, World Bank, and GIZ. She has obtained both legal state exams in Frankfurt, Germany, as well as her PhD, and is also qualified and certified as a mediator. Mrs. Caryl Lashley is a barrister of more than 40 years, standing with experience in litigation, family, corporate, employment, and trust matters. She is a fellow of the Chartered Institute of Arbitrators, and she's proficient both as an arbitrator and a mediator. Her professional memberships includes the FIDA, the International Federation of Women Lawyers, the Society of Trust and Estate Practitioners, Mediators Beyond Borders International, Mediate.com, Mediator Academy, the International Bar Association, the Bahamas Bar Association, where she served as secretary from 1992 to 1995, and as chairpersons of the Ethics Committee from 2000 to 2017. She is currently chairperson of the ADR Committee of the Bahamas Bar Association. And she has been a fellow of the Chartered Institute of Arbitrators since 2012. And in 2014, she obtained an advanced certificate in trust and estate mediation from STEP. Having been designated by the Bahamas government to serve on the ICSID panel, she was a panel of arbitrators and conciliators. She was redesignated in 2020 to continue to serve on this panel for an additional 6 years. She has also been invited to participate in ICSID's first mediation training in June 2017 and at the World Bank in Washington, DC. Most recently, she undertook to train the trainer mediation training with Ken Cloak in April 2018, and similar training offered by the Chartered Institute of Arbitrators in 2015 and 2020. Determined to encourage, educate, and strive for peaceful and amicable resolutions to conflict, in 2016, she founded ADR Bahamas. to provide education and stimulation for nonviolent communication and conduct, and provided neutrals to facilitate conflict resolution. She is also a member of the Bahamas Real Estate Association, and her civic memberships also include the Nassau chapter of the Links Incorporated, where she was the charter president, the AIDS Foundation of the Bahamas, where she served as president for 5 years, and the Public Education and Resource Committee on HIV/AIDS. She's also a board member of the Elizabeth Estates Children's Home. Widowed, Mrs. Lashley is a proud grandmother and mother of 2 adult sons. Mrs. Kelphene Cunningham is a retired judge of the Industrial Tribunal of the Bahamas. She is the first Bahamian Fellow of the Chartered Institute of Arbitrators, London. She is the first vice chair and a founding member of the Bahamas' branch of the Chartered Institute of Arbitrators. She has been a member of the Chartered Institute of Arbitrators, London since 2008. Some 2 years before the Bahamas branch was established, as she had a clientele base which required those services. Mrs. Cunningham is a barrister at law of England and Wales, a member of the Honorable Society of Gray's Inn, and a member of the Bahamas Bar. She holds a Master of Laws degree in International Dispute Resolution, a Bachelor of Laws degree, a postgraduate diploma in Commercial and Corporate Law, and a postgraduate certificate in Equity and Trust. She is an experienced international and domestic arbitrator, and she has certifications in advanced mediation. She is also an experienced negotiator and adjudicator. She is experienced as counsel, and she presently operates a boutique law firm where she practices litigation, family, probate, commercial and corporate law, mergers, and employment law. As I said earlier, my name is Theominique Nottage, and I work with the Ministry of Financial Services, Trade and Industry and Immigration as a consultant, and I lead the recently established ADR unit. My educational background is diverse. I have studied in the United States, the United Kingdom, the Bahamas, Costa Rica, and Spain. I hold a Bachelor of Arts degree with integral honors in international studies in Spanish, a Bachelor of Laws degree with honors, a legal education certificate, and a Master's of Laws with merit in comparative and international dispute resolution from Queen Mary University of London, where I studied as a Sheeping Scholar. I'm admitted to the Bar of the Bahamas since October 2015, and I've held several leadership positions in different professional organizations relative to arbitration. So I've been with the ministry since August 2020, and it's my pleasure to join you all here today. And without further ado, we're going to welcome Ms. Knieper to begin her presentation on the UNCITRAL Mediation Framework. So Ms. Knieper, whenever you're ready.
Yeah, thank you very much. I would like to share my screen, and I just see that screen sharing is disabled. Could we do something to change that? Or should I send someone the presentation, or?
Are you able to screen share now?
Let me see. Now it's working perfectly well. That's perfect. So let me see where I can start the. Now we are there. You all see my screen?
Yes, we can see it. Thank you.
Perfect. Yeah, it's a little bit difficult in this virtual setting. It's difficult to see nodding if all the cameras are switched off. So my topic of today is the UNCITRAL Mediation Framework. When we agreed to do the webinar, we agreed on a different topic, and that was the UNCITRAL, the United Nations Convention on International Settlement Agreements Resulting from Mediation. The reason why we enlarged the topic is that at the last Commission session in July of this year, we adopted 3 new texts, 3 new instruments, which makes it possible now to really speak of a comprehensive UNCITRAL mediation framework. So we do have, since July, we do have the UNCITRAL mediation rules, we do have the UNCITRAL notes on mediation, and we do have the guide to enactment and use. And what I want to do during this presentation is present each of these texts very shortly. As we are not so many people, I suggest that if you have any questions, just jump in and ask your question, and we can take it from there. So the first instrument I want to talk about, and this is also because it's by far the most important one, it's the key pillar of this whole UNCITRAL mediation framework, is of course the Singapore Convention. Currently, we have 54 signatory states, including 6 parties, and you can see on the map that these parties are quite everywhere. You will also see that the Bahamas has no dark color yet, so I do hope that we can change that quickly. What is the aim of the convention? It's to establish and thereby to close a gap, to establish a harmonized framework for, on the one hand, the enforcement of settlement agreements, and on the other hand, to allow to invoke such settlement agreements. And that gives business community an additional tool of reliable dispute settlement instrument, which is why it's probably not by accident that a number of Chamber of Commerces want to really go into this topic of mediation, and we can see everywhere that there's a lot of appetite to take the topic on. So to go very quickly, because many of you might already know the Singapore Convention, the scope is on international settlement agreements, resulting, of course, from mediation concluded in writing by parties to resolve a commercial dispute. There are some exclusions from the scope, as you can see on the slides. What we always have in all of our instruments is some extensive definitions. This is because our instruments are drafted by around 90 states from very different geographical areas. So if we do want to draft an instrument, we need to make sure that everyone is having the same approach and the same understanding of some key terms. We have done Article 3. Article 3 is the article of the whole convention because it defines the core obligation for state parties. And this is that it must allow for the enforcement of a settlement agreement in accordance with the state's rules of procedure and under the conditions laid down in the convention. And it should allow the right to invoke a settlement agreement, again, in accordance with the parties' rules and under the conditions laid down in the convention. The requirements are laid out quite clearly in Article 4. So you have the signature by the parties, the evidence that the settlement agreement really resulted from mediation. There you have different means to provide evidence, translations, and any other document that might be necessary to make sure that so that the authority can make sure that the conditions of the convention are met. Article 5 is also a key article. That was the article that caused most headache in our discussions, which ones should be the grounds for refusing to grant relief. For those who do know the New York Convention, you will notice that the approach is similar. Of course, the grounds for refusing to grant relief are different because the procedure of mediation and of arbitration are different. So you have three big reasons. You have those reasons that are dealing with the disputing parties, for instance, the incapacity. You have those grounds that relate to the settlement agreement as such, and you have those grounds that relate to the mediation procedure. You have then one article, what happens in the case of parallel application, what are the possibilities of the competent authority in such cases. You have an article that again mirrors a similar article of the New York Convention, and that is that the most favorable law or treaty should be applicable. Then you have an article that is key for states when they decide to adhere to the convention, and these are the reservations. We have two reservations. The first one gives governments the possibility to exclude agreements with governmental agencies or persons acting on behalf of a governmental agency being a party. This is a reservation that is particularly relevant in the discussion of investor states dispute settlement. Should the convention apply in these cases, yes or not? So this is a decision the states have to take. I may inform you that we have a working group dealing with investor state dispute settlement, working group 3, and there a number of states are very keen on promoting mediation in the frame of investor states dispute settlement. Then you have a second reservation, and this reservation has been included because a number of states were fearing that parties to a dispute might be to a settlement agreement might be subject to the convention without knowing. So this is a reservation that has some educative impact, and the reservation says the convention should only apply in case that the parties to the settlement agreement have agreed to the application. So you have an opt-in to the parties. For the time being, from those states that, from the 6 states that did ratify, no states raised this second reservation. Then you have the clarification that settlement agreements concluded after the date of the entry into force are under this this convention. You have some further articles which relate to the usual articles each convention should have. So who is the depository, how to exceed, how to withdraw reservations, and so on and so forth. So the main key message is, and what this convention does is it gives settlement agreements resulting from mediation a special status and renders these settlement agreements directly enforceable and invocable. So this is certainly something that closed a gap. We could see before the entry into force of the convention that mediation was something that was more and more considered in commercial dispute, but the big fear raised by many was how to we ended the dispute, we had a a procedure to find a solution, and in the end we just have a normal contract. And this convention closes the gap and gives a special status to the settlement agreement, makes it by making it enforceable. If you ask states what were the reasons for their adopting the Singapore Convention, so the main reason is certainly that they are able to have an additional dispute resolution tool at the disposal of their businesses. But this is only one. The other reason is all related to the widespread of the convention. We can see that a number of states are taking up the convention. There are a number of states that are still considering signing. A number of ratification procedures are currently underway. And that means that you have an instrument which is dealt with by numerous scholars all over the world. They are all talking about an instrument that is equally accessible to everyone. It's available in the 6 United Nations languages. It's available in many more languages in which it has been translated. You have a number of events taking place all over the world. So we could see that the impact is really there. And I would like to take the opportunity to invite you to the Singapore Convention Week we are organizing next week, UNCITRAL and Singapore, to further promote the convention. So if you just go on Singapore Convention Week, you have the whole program and you can join bits and pieces, or you join the whole week. I guess there's a number of interesting activities taking place there. The second important text that has been adopted is the model law, which has really a very long title, so I'm not going to read it, not to spend all my time. This has been an update of the model law of 2002. The model law of 2002 has the overview of the whole procedure, and what has been done when the Singapore Convention was drafted was to add the section on enforcement to the model law to make sure that the model law and the convention are in compliance and could be used together. So you could use the model law as a standalone text, you could use the convention as a standalone text, or you might use the model law in order to implement the Singapore Convention. The idea, like for the convention, is of course to provide uniform rules relating to the process, and as well to encourage the use of the procedure. Here you see an overview of the different aspects that are dealt with in the model law. I'm not going into details because the draft bill we were receiving from you is covering all the issues, and as the draft currently stands, it's definitely a model law compliant. This is something that the guide to enactment, you see, we love long titles, so this title is also quite impressive. The idea of this guide to enactment in use of the model law is to provide the background and to summarize the discussions that took place in the working group and in the commission when the text was adopted. So it gives you, and especially if you take over the model law, it gives you quite a good insight into the understanding of the different provisions and what are the key elements to take care of, to maybe to see what elements legislators still have to decide. So all of that is explained, and this text has now been adopted by the Commission in July of this year. As well, the mediation rules have as well been adopted. They are an update of the conciliation rules. The conciliation rules, you will notice the different terminology. In 1980, when we started with the first text, the leading term at that time was still the term conciliation. In the UNCITRAL context, the two terms have always been used interchangeably. So conciliation with the understanding that it's another expression for mediation. So from our perspective, it's really the same. In different contexts, it's a different procedure. For instance, if you take the case of ICSID, you have ICSID conciliation rules, and now you have also ICSID mediation rules, and they really mean a different procedure. In our case, the terms are used interchangeably. So the changes that have been made to the conciliation rules were to first align them with the newly adopted text, so with the Singapore Convention on the one hand, with the model law on mediation on the other hand, but also to reflect development of the developments of the last 40 years. Now I would like to pass the floor shortly to Jonathan, who has worked on this slide, and he will explain you what it means and what it entails. So Jonathan, the floor is yours.
Yes, thank you very much, Judith. Firstly, I would like to briefly highlight that the Secretariat is currently devising recommendations to assist mediation centers and other interested bodies that envisage using the UNCITRAL mediation rules in the institutional context. So in particular, the recommendations aim to assist institutions with using the mediation rules as a model for drafting their own institutional rules, utilizing the mediation rules in administering disputes or rendering administrative services in ad hoc mediation, as well as the recommendation and or selection of potential mediators as provided by and in accordance with the rules. And in this light, the Secretariat is also currently in the process of compiling a non-exhaustive list of mediation centers which have institutional rules based on or inspired by the UNCITRAL mediation rules, facilitate mediation or provide administrative services under the rules, and recommend and or select potential mediators under the rules. And the lists would be published on UNCITRAL's website and follow a similar format to the table indicated on the present slide. Moreover, the Secretariat is hopeful to include several mediation centers on this list by the end of the year. Back to you, Judith.
Yes, thank you very much. This is related to a task we got from the Commission, and like in the area of arbitration, we have UNCITRAL arbitration rules. They are applicable in the ad hoc context, but we issued recommendations how to use them as an institution. So the Commission asked us to do the same for the mediation rules. This is what we are currently working on, and this is the table where we hope to include a number of names of mediation centers. For the time being, it's still empty because we are just in the process. The rules have just been adopted, and we are just in the process of trying to compile the information. Then the last text that has been adopted at the Commission session this year are the notes on mediation. The notes on mediation are a general description highlighting all the issues that might come up during a mediation. So it's prepared as an introduction to practitioners, to parties who would like to better understand how mediation is working. And the rules, the notes are, and this is why on the last slide, which summarizes the whole UNCITRAL Mediation Framework again, the rules and the notes are already now at the disposal of all parties. For the convention and for the model law, you of course need states to adopt these texts. If they are not adopted, it's difficult for private parties to take advantage of these texts. And the rules, contractual rules, the notes, explanatory background are usable as of now. So this is really something that private parties could consider as of today. And with that, we close our presentation and look forward to receive a lot of input by you, questions, also what we could do further to promote mediation, if we might expect if we might expect the signature or even ratification by the Bahamas. That would be, of course, good news we would like to take home. I give it back and hope we have a very lively discussion now. Thank you.
Thank you so much for that engaging presentation. We really appreciated it. Mrs. Cunningham, if you're able to start the presentation now, I'll pull up your PowerPoint for you.
Thank you very much. This is a draft bill of the International Commercial Mediation and International Settlement Agreements resulting from mediation. It's a 2020 bill. It's not yet been debated in Parliament, but it's a draft. And what I intend to do is to go through the draft and hit the high points of the bill and go through the articles one at a time. When we look at Article 1, this bill deals with international commercial mediation. So we look at the definition for commercial, and commercial has a very wide definition. It's a very wide definition. It includes, for the interpretation, it extends to, it means any trade, transaction for supply or exchange of goods or services. It extends to leasing, construction, engineering. So it's given a very wide meaning. And this bill concerns international mediation. If we look at the interpretation of international in Article 3, and we look at the interpretation, a mediation is international if, for example, the parties to an agreement to mediate have, at the time of the conclusion of that agreement, their places of business in different states, different countries. So, for example, someone in Abaco and someone in Nassau having a dispute, that's not an international mediation. We're all in the same countries. Article 4 provides that the parties may agree to exclude or vary any of the provisions of the bill. I'm going to go through this rather quickly because I'm only allotted so much time. Article 5 deals with commencement of mediation proceeding. And mediation commences on the agreed date of the dispute, and the time period for accepting an invitation to mediate is 30 days. Article 6 deals with the number of mediators. Parties can choose 1 or 2 mediators, and it's to be agreed by the parties. Article 7 deals with the conduct of mediation, and that is by agreement, and there must be equal treatment of parties. Article 8 deals with freedom to communicate between the mediators and the parties, and the mediator may meet or communicate with the parties together or with each of them separately. Article 9 deals with disclosure, and disclosure is always versus confidential information. But there's always a need for open communications between parties and the mediator. Article 10 deals with confidentiality, and you have the general rules of confidentiality that applies to even arbitration, and it's always the party autonomy. And Article 11 deals with the admissibility of evidence in other proceedings. In general, you have the prohibition on the use of information obtained in mediation for the purposes of other proceedings. Article 12 deals with the termination of mediation proceedings, circumstances in which a mediation proceeding may terminate. It can be terminated by settlement agreement, declaration of mediator, declaration of parties to mediator, declaration of a party to the other party plus the mediator. And then you have Article 13, mediator acting as arbitrator. Now, this is the default rule, and a mediator shall not act as an arbitrator. Article 14, resorting to arbitral or judicial proceedings. There's a limitation of the freedom to initiate arbitral or judicial proceedings. And this is when you're doing a mediation, you must keep it separate from the arbitral proceedings. The rules are different. Article 15 deals with the binding and enforceable nature of settlement agreements. And if the party concludes an agreement settling a dispute, that settlement agreement is binding and enforceable. And it's enforceable as an order of the court. And I think Judith has touched on that already in the Singapore Convention. It is now, the settlement agreements are enforceable, and that brings finality to it and lots of comfort also to persons who are engaged in international mediation. Article 16, the scope of application. International agreements resulting from mediation and concluded in writing by parties to resolve a commercial dispute. Now, there are exceptions to the scope of international mediation, and it does not include, for example, it does not apply to family matters, inheritance, or employment law matters. And settlement agreements must be in writing, and it contains recorded. Of course, even though it must be in writing, it can be in more than one document, and electronic communications are acceptable. And of course, now under Article 17, that has now been embodied in the Singapore Convention, as we've just been told. You have direct enforcement, and it removes all ambiguity. Article 18, requirement for reliance on settlement agreements. You would have to ensure that it's been signed, party signature, evidence that the settlement agreement resulted from mediation. And I mentioned electronic communication is admissible. And there is no need for the document to be in for the agreement to be in one single document. Grounds for refusing, and under Article 19 of the Act, incapacity, inoperative, not final, not clear, or subsequently modified, serious breach by the mediator, lack of disclosure, and of course, public policy always raises its head. It can be refused because it breaches public policy. Article 19, parallel application or claims. The competent authority of state may decide to order other party to give suitable security when there are other applicants. So you're dealing with security for course in matters of this nature. And Judith indicated that the Singapore Convention is now in force. Well, it's been in force from September 20th, but you now have the rules are there for the Singapore Convention, and that Singapore Convention ties in, as you know, greatly to this international commercial mediation because it deals with enforcement. And prior to the Singapore Convention, it's been a welcome relief because prior to that, persons may have gotten a settlement, but if the other party ignored it, they could not, the enforcement was the difficulty. They had to go to the local courts and they had to enforce it as a contract. And now it's enforceable under the convention once you've signed on and you've ratified. Thank you very much for your attention. And that completes my presentation.
Thanks very much, Mrs. Cunningham. Mrs. Lashley, I would invite you to present on the Domestic Mediation Bill.
Thank you. And I'm pleased to speak to endorse and repeat largely, to a large extent, what both Judith and Kelphene have said, because we have tried in the domestic drafting to also be on all fours with the international settlement of mediation rules. And to that end, our difference really is that the scope of the application of law, which is Article 1, and whereas in the Singapore Convention and our international bill, we talk about international, and in ours, we talk about domestic. The only other difference that we have in our bill would be that we have included an article which enables the competent authority to provide regulations for any matter referred to in the bill, in the act. And it would also include factors such as the role of practicing attorneys, if there would be an ADR council established, there would be regulations relative to conduct of mediators, training of mediators, how they act as neutral, serve on the council, and maintain and retain their accreditation, because it is envisaged that in the domestic regulations, there will be provisions for the mediators to be properly trained, B, become accredited, and C, to retain and maintain their accreditation, which would include so many hours of mediation a year, which will include engaging in continual professional development. There would be the two main aspects of the regulations. And then, of course, just like the international, the domestic will have their settlement agreements be dealt with as if they were an order of court and not just as a contract. And that would be the other important aspect of the domestic legislation. As with international, most of the areas are based on the agreement of the parties. Same rules relative to the importance of confidentiality as is with international. And the issue as well, in terms of language, the language of the mediation shall be the language of the documents containing the mediation agreement. And so we won't have, as an international, we won't have the 6 languages of UNCITRAL, but we will have the framework in our rules that enables the parties to make a determination on those sorts of things, including how the mediation is terminated, as mediations are otherwise. And so, as I indicated, the difference is that it's domestic, and that we will have some rules provided through the competent authority. And we're going to be available to everybody who's on the meeting and who might not be on today, but who might have liked to have been on, to provide further information and to get some input on where we are going from here. Because as Mrs. Cunningham has said, we've pretty much completed the drafting, both of domestic and international, for the Bahamas. And so unless I can answer any questions for you, that's really all that I have to say on the Domestic Mediation Bill. Thank you.
Thank you so much, Mrs. Lashley. I'll just slide right into my presentation, which I'm going to keep short because I'm sure there are going to be a number of questions to each of you about what we've talked about so far. So, share screen. So I am going to be talking about the role of the government. So we all know that for the past 2 decades, the Bahamian government has been talking a lot about alternative dispute resolution. In particular, the focus has been on international arbitration. And by that, the government had enacted in 2009 2 key acts, the Arbitration Act 2009 and the Foreign Arbitral Awards Act. So in 2020, the ministry decided to take a renewed focus on what they would be considering for alternative dispute resolution. And that focus was expanded beyond arbitration to also include mediation and construction adjudication. So when we talk about the Bahamas as a center for alternative dispute resolution, we aren't focusing primarily anymore on arbitration, but we're also including mediation as the next big thing, and also construction adjudication. So the ministry has looked at the different strengths, weaknesses, opportunities, threats to the Bahamas as a center for ADR. I don't want to get into the details of that just because I want us to have sufficient time to have a good, healthy discussion on mediation. So I will move directly on to the International Mediation and Domestic Mediation Bill and skip over the establishment of the ADR unit, which was established August 2020. And we've done a number of things since 2020, including the introduction of a 2-year strategic plan, the final amendments to the International Commercial Arbitration Bill 2018. We're still working on amendments to the 2009 Arbitration Act, and we are working on construction adjudication as well. So back to the International Mediation Bill and Domestic Mediation Bill in relation to the role of the government. So this ministry, Financial Services, Trade, Industry, and Immigration, is responsible for alternative dispute resolution as it's a complement to financial services and other parts of the government that fall within the mandate of this ministry. So what this ministry intends to do is to create a government policy on the Singapore Convention and aim to ratify that convention and to incorporate the Singapore Convention into domestic law by virtue of the International Mediation Bill. In relation to the Domestic Mediation Bill, or the government intends to draft and enact the legislation that would support domestic mediation. So the bright side and the positive side here is that we have met with our industry stakeholders, particularly Mrs. Lashley, Mrs. Cunningham, retired Justice Ruby Nottage, Mrs. Bertha Cooper-Roselle, all members of the Chartered Institute of Arbitrators Bahamas branch. And we've had discussions with them on these bills from September of 2020. So having met with those industry stakeholders, we have half of the work done by their brow and by their sweat, that they've done a lot of the heavy lifting and drafting the legislation for us. So now the government's role is to get that legislation from draft form into enactment. So what will happen is that there's going to be light benchmarking. We accept that UNCITRAL has approved the draft bills. So the benchmarking is going to be done with a very light touch, just to ensure consistency and that nothing has been overlooked. After that light benchmarking is done, we're going to go back and meet with our industry stakeholders. At this ministry, we think it's very important to collaborate with our strategic partners, in particular, the Chartered Institute of Arbitrators branch. And from the benchmarking stage, we're going to prepare a memorandum to cabinet. So cabinet approves the draft bills in their form. And then once the bills have been approved by cabinet, it goes to the Law Reform and Revision Commission. Now, the Law Reform and Revision Commission is made up of professional draftsmen, and they will also go over the drafts that we present to them just to make sure that it's in its proper form and that it meets the requirements of the Bahamian government. Once that happens, the Law Reform and Revision Commission sends it back to the ministry. It goes back to cabinet for another approval. And once cabinet gives its final approval, the minister who is responsible, and that would be the Minister of Financial Services, Trade and Industry and Immigration, will now have approval to have that bill tabled in Parliament. Now, there are a lot of tiny steps in between that, which I don't think I should get into right now in the interest of time, but it's going to be a longer process to get these bills enacted. But we're hopeful that we will be able to get that done at some point in 2022, as we already have the first drafts of the bill done, and the work to be done on the bills will be just very light revision and very light benchmarking. So we're thankful to our strategic partners like the Chartered Institute of Arbitrators and the members that we have met with who have done the work. And that is the end of the presentation in terms of the role of government. And I would now want to open up the floor to any questions that anyone may have to any of the presenters today. Are there any questions from anyone? You can submit it in the chat box, or you can feel free to unmute your mic and ask a question.
May I ask a question?
Sure, no problem.
You did a lot of efforts now in drafting all of these bills. And my question would be, are you also considering signing up to the Singapore Convention? Is that also in the process, or?
Yes, that is a part of the process. We've discussed that internally at the ministry and have reached out to the ministry that's responsible for entering into international agreements such as the Singapore Convention to have that done alongside the enactment of the bill. I can't give you an exact timeline on that just because this is what's going on in the country presently. We're in election mode, so I can't give a timeline on it, but we do anticipate that it will be done within the next year or so.
That's good news. Thank you.
There is a question in the chat function, and the question is, will the draft bills be circulated for comments? Yes, there will be public consultation on both of the draft bills. I don't see that we have any other questions, so I'm going to put a question to Mrs. Lashley, Mrs. Cunningham, or Ms. Knieper. I get a lot of people approaching me asking about how they can become qualified in mediation, or there's a postgraduate diploma or a Master's of Law program in mediation. I wondered whether you can, give some insight to any of the participants here today who may want to be qualified or become qualified as mediators or seek additional academic qualifications in mediation.
Well, I'll start from the bottom. I'm probably the least who could speak, but there are very many organizations and bodies who provide training. Obviously, I speak from the perspective of the Chartered Institute of Arbitrators. That's where I started my training. I believe, however, that the wider the scope that you seek, the better you might have a feel for whether or not this is what you really want to do. Because having done mediation training the very first time through the Chartered Institute, I think I had the grounding, but I think there was a lot of other information that I had to get and I obtained along the way, which enabled me to expand upon not only the knowledge that I had from my basic training, but also what additional stuff I had to do to become proficient. And I said that to say that the initial basic training is something that you have to become a mediator, but that might not be enough for you. So you have to know what you need to know to do that. But there are very many opportunities for training, both in the UK, Europe, and North America, and probably other places as well, but that's what I know, so that you could get your training done relatively easily. And also, particularly in the pandemic, you don't have to travel so much. You could do it. Most of the training is now virtual.
Well, I think, Caryl, you left off one very important area of training. We train right here in the Bahamas, and you yourself is one of the faculty members. And we have just had early in this year, I think just early in this year, last year, time just sometimes is moving so fast now in the pandemic, but we have just come out of a training course. The mediation was conducted by Caryl Lashley herself, who is a faculty of CARB. And we also had introduction to arbitration. But since we're dealing with mediation today, I believe even at our meeting yesterday that our chair, the chair of CARB, must have said something to the effect that it's time for us to perhaps see who is interested in another training course. So, and that would give you the basic training. And as Caryl said, that she training to advance our skills. But that's the basic training that you can get in mediation is trained right here locally. And perhaps this is a good time for the chair of CARB now to send out a memo to canvas to see how many are interested, because I think you've got to have X amount to do the course. So that's the basic starting. And then, of course, which you did not say, but Caryl has a vibrant ADR practice, and even she brings in people. I sat in, I'm a member, and I sat in on several of them. She brings in people from time to time. And so start here first with us. It's quick, it's easy, it's inexpensive, the CARB, and then you perfect your skills by doing further advanced training. Okay, thank you.
And you might do that advanced training maybe by joining the Singapore Convention Week next week. So you have already the whole package. I put the link to the to this conference in the chat.
Thank you so much to each of you for addressing that question. Does anyone else have any additional questions?
Can I ask you a question, please, Ms. Nottage, or any of the panelists?
Yes, Justice Charles.
I'm wondering, I may have missed some of these conferences, so I apologize for that. I'm not sure how far you've gone. Is the mediation, the domestic mediation, going to be court-connected mediation? I mean, if a matter comes before me in court, and I want to refer it to mediation. I say that because you know, I came from the Eastern Caribbean Supreme Court, where the new rules have been implemented since in 2000, and in the new rules, there is something called court-connected mediation, which means that I am the judge or I'm the master of the court, and I see a dispute, a land dispute, which I feel should go to mediation. Why are you wasting my time in court? I, as the judge or the master, will say to the parties whether or not they consent. We would like them to consent. But if they don't, I could say, hold on, why are you going to waste my time? It's going to take 5 years in the court. Sorry, I don't mean that long, but you know what I mean. Can I send it to mediation? And in the Eastern Caribbean, there is a body of mediators in all different subject matters, construction and engineering and whatever. The judge has the roster and the judge can select and ask the parties, of course, with their consent, to select one of those mediators. Is that what we're going to have here? Like if I have a case that I see fit for mediation, how do I send it to you? That's probably my point.
Well, if I could take that, I think that we are on the way there because we do not have in place the roster of mediators with their skills attached that's before the court. We also do not have the rules of court put in or revised so that the parties can be sent off by the court to go to mediation rather than waste the court's time. However, many parties who are represented by counsel, I think, have left their matter, had their matters adjourned so that they might give consideration to mediation, and their counsel would have sent them out and said, they know that there's some of us who do mediation, go and talk with the mediator and see if we get it resolved before we come back to court. And so the judge would have given an adjournment of 2 months or whatever the period is so that they can go to mediation, but the formalities are not in place. Not at this time, but it does happen. But the counsel would have to then assist their clients in that regard at this stage to go to mediation.
Thank you.
That answers your question.
Yeah, no, I just wanted to know how, because normally once it goes to mediation, once the judge or master makes the order, proceedings in the court are stayed pending mediation. Then they come back and report, yes, we've been successful or not successful. And so the court makes an order at that stage. But I hear you. I appreciate your point. We probably will get there at some point in time, no?
Hopefully.
Okay.
We're definitely on the way, I think.
Okay. Thank you.
Thank you to each of you for joining us this afternoon. I see we're past the 5 o'clock hour. I just want to reiterate that the recording of this webinar and the materials associated with it will be made available via the Bar Association's listserv. Hopefully by the end of the week, we can get that to you. And again, I thank each of you for joining us. And we're happy to answer any questions via email that you can submit via the bar's list, via the Bar Association office or directly to any one of us if you already have our contact information. So thank you again to Ms. Knieper, Ms. Cunningham, and Mrs. Lashley, and to each of you for joining us this afternoon. Thank you.
Thank you very much.